Your LLC may not save you if you don't have this. Thousands of business owners think their LLC fully protects them. They paid the fees, they did their articles of organization, maybe they got a bank account, they filed the paperwork, and they even get a fancy certificate associated with the company, but there's a massive problem potentially lurking below the surface. Courts routinely pierce the veil of LLCs that can't prove that they're a real company. And if they're missing this specific document, it's really hard to prove that this company is bona fide and not just your alter ego. The missing document is an operating agreement, right? Because this can make the difference between full limited liability protection and an opportunity for someone to pierce the veil and get to your personal assets. I'm Jonathan Feniak. I'm a business attorney, and I've helped thousands of founders and entrepreneurs start and run their companies. I'm also the lead attorney at LLCattorney.com. We're not a law firm, but we've helped more than 80,000 founders and entrepreneurs start and run their companies and maintain compliance. If you think your LLC, after you set it up, is just impenetrable, I'm good. I did it. I started. I'm good to go. It's in the Secretary of State records, and you're totally protected your personal assets, you got to think again, okay? Because without proper documentation, and the most important piece of documentation is that operating agreement, the courts may decide that your LLC is just a mere shell. They may not treat it as a real business. That foundational document prevents what we call piercing the corporate veil. When we're talking about LLCs or corporations, we still call it piercing the corporate veil. But what it means is that they can just ignore or get through, someone who's suing the company can get through that shield, that limited liability shield, and go after your personal assets, your car, your savings, even your house. An operating agreement proves you're taking the company seriously. The operating agreement sets up the rules for the company. And if you don't have an operating agreement, you are going to be held to the default rules listed or named or written out in the limited liability company statute for that state. And you may not like those rules. An operating agreement establishes the corporate formalities that you're going to follow, and it shows you're taking the business seriously. If you don't have an operating agreement, you're going to be held to the default rules in the limited liability company law for your state. If those laws say that meetings must be held in a very specific way, there's got to be notice sent out, the meeting needs to be recorded by a secretary, and this and that and the other thing, if you don't follow those things, your meetings and the activity you're engaging in may actually be invalidated. But if your operating agreement says meetings can be held as needed without a notice period, or notice is waived, or they can be held, without even a formal meeting being called, if it gives you that flexibility, it's really easy to comply with the terms of your operating agreement. So there's an idea here, don't make it more difficult for yourself than you need to in your operating agreement, and give yourself a really flexible way to run your company. If you have more than one owner or member of your LLC, an LLC without an operating agreement is just asking for trouble. One of the most common things I see is not actually the company being sued, but there being a dispute among the members. The other thing that an operating agreement does for you is that it creates a level playing field with clearly defined rules about what authority people have, what the decision-making process is, what the rules are in terms of voting, all of those little things, which gets everyone on the same page and prevents those member disputes. So it's going to be really important to have an operating agreement that everyone involved agrees to. Who needs to worry about having an operating agreement? Who needs to worry about it most? You're not required to have an operating agreement by law. And the states know that most people won't have an operating agreement, so they are held to the default rules in the law, in the statute. But you don't likely want to follow those rules. You want to establish new rules for your company. So it's incredibly important for multi-member LLCs, for startups when you have more than one person involved, it's important to lay that foundation of what the rules are from day one. Otherwise, you're playing a game you don't know the rules to, or you may be held to rules you definitely don't like. However, even if you have a single member LLC, I highly recommend having an operating agreement because, again, those default rules can be more onerous and likely will be than the operating agreement you put in place, and you won't even know what rules you should follow because of the onerous nature of those limited liability company statutes. So the operating agreement should define who does what, who owns what, how everyone gets paid, and every detail involved when you've got more than one member, because you're at the high point at the beginning of forming a company. You and your partners are excited and you're going to have agreement. Later on, people can get frustrated, emotions can run high, and that could lead to people having very substantial disputes in areas where if you don't have an operating agreement, it wasn't even discussed. Family businesses especially can benefit from having an operating agreement because it can address tricky questions like what happens if mom retires? She's the one who's been running the company. How do we handle conflicting interest? What if one of the family members passes away or gets divorced or has financial problems? What happens in those situations? And even if you're in an LLC with your family, it's a business first and family relationships should come second. One of the most important things an operating agreement can do is force the conversation so everyone's on the same page. And I have found that sometimes people who are anticipating going into business with each other didn't do it because they couldn't come to an agreement at that point. They couldn't even get to the point where they started because of really foundational disagreements they were having. So that's a truth bomb for you, right? If you can't agree on the operating agreement, that foundational document, maybe not a good business partner. The document really is going to try to and attempt to and should resolve these fundamental differences and really establish that good working relationship with your partners. If you're arguing about splitting profits or who's going to do the work or what authority do I need and you can't come to an agreement, then you can just imagine how this would play out in the real world of operating a business. It's going to be something you need to consider very, very seriously if you can't come to an agreement on an operating agreement. If you wait until 6 months or a year after the company's been around, it's really hard to get people to agree, and you may be in a position where getting out of the partnership, getting out of the LLC is not even an option under state law. At LLCattorney.com, every company we form comes with an operating agreement. It's not an add-on. We're not forcing you to decide, do I want an operating agreement? We have designed what we do based on the guidance of attorneys, and we believe everyone should have an operating agreement, so we give it to you for free. Not having one really exposes you to this potential risk way down the road with being in court, defending a veil-piercing attack on your company, or trying to settle a dispute with your partners. One of the other things we offer at LLCattorney.com in certain states is what we call a custom operating agreement. I used to draft custom operating agreements for my clients, and it would cost thousands of dollars. But what I found was the overwhelming majority of concerns and points of potential conflict were the same. And so what we did is we created technology with a very simple questionnaire, 25 to 40 questions, depending on what it is you're deciding or the things you want to address. You can create an operating agreement that addresses things like what is the exact responsibility of each person? What is their authority in terms of dollar amount they can spend? What happens if someone wants out of the partnership? What happens if someone dies? What happens if they're having financial problems? All of those things can be obtained with the custom operating agreement for a really, really modest cost compared to what it would cost to have an attorney draft that custom operating agreement for you. So you get, no matter what, you're going to get an operating agreement, but if you need that extra step, if you've got business partners, I highly recommend you look at and investigate the custom operating agreement option. And at the end of the day, whatever you decide, sign the operating agreement. Get it signed. Everyone needs to sign, And if they need their attorney to look at it for them, if they have a personal attorney, then so be it. But without the signed operating agreement, you really don't have anything.